record for Tierra Butler.
Yes, Your Honor, thank you. This is State of Indiana versus T.R. Butler, cause number 64D012306F65582. Defendant appears in court in person and with counsel, Mr. Steve Pribble. State of Indiana by Gary Gurman.
State, you asking for a jury setting?
I am, Your Honor.
Okay. I want to note a couple things for the record. Ms. Butler, I received a pro se filing from you yesterday. There were some documents and things mailed to the court. Do you recall doing that? You recall sending this to the court?
I sent it to the young lady, yes.
Okay, so I am going to scan this, put it up into your file, but I just want to note for the record that we don't permit what's called hybrid representation, okay? So you have counsel, you can't also submit matters on your own behalf. Anything you want to submit to the court, you have to submit through your attorney. Do you understand that?
Yes.
You do understand that?
Yes.
Okay, and then the matters that you submitted aren't matters that we understand in this court. You submitted what we refer to as pseudo-legal jargon or matters that are contractual in nature and have nothing at all to do with a criminal court case. So I'll upload them into the case, but I'm also going to strike them from the record. Okay? Just so you know.
Mail that to the clerk. I didn't mail it to
at 9 a.m. You may take it.
That's private that you have, the documents that you have.
Do you have another case pending somewhere in the court system other than this one?
It's just this case here. Those was private documents. It wasn't for public only.
Is this something you want to file with the clerk?
No, it wasn't filing with the court. No, it wasn't supposed to file with the court. It's supposed to file with the head clerk, Jessica.
And are you trying to file a case or something other than in this case?
It's referring to this case, yes.
Okay, so
Yes.
we'll upload them into the file and strike them from the record, as I mentioned.
Before we adjourn, Your Honor, I know Ms. Butler wanted to make a statement if court would allow that.
Okay, go ahead.
How you doing? The reason why I might have to let Mr. Pribble go because I'm not being helped with my case. There's a lot of violations that happen towards me. There's a lot of my evidence has been tainted, and it's a one-sided case. There's a lot of due process violations that occur, and no one want to listen. Everybody's being selective-minded, and I just want to address that to the court. I have so much evidence
Mr. Hampton,
that I
what's
have
wrong with you?
presented
Why'd you
in
do
this
that on
court
your way out?
to show you, to prove to you, show facts, and also show you there's a lot of concealment
Counsel,
within this
here's what
court.
I'm going to do. Mr. Hampton,
So
that
I'm
behavior is
asking
not
you,
going to be
can
tolerated
you
in my courtroom at this point.
address somebody to assist me in that matter?
Ma'am, we appointed the Porter County Public Defender Service, I believe, to represent you. Are you in this matter privately, Mr. Pribble?
At 9 a.m.
So we appointed the Porter County Public Defender Service to represent you, ma'am. I appoint them and then they appoint a lawyer. So you've got Mr. Pribble involved in the case. You can't pick and choose what lawyer you get when you ask the court to appoint counsel for you. You get what you get.
I get that, sir.
Okay?
But only thing, the reason why I ask is because I feel like I'm not being helped. I see like I can do it myself and present this as pro se, but evidently it's just being delayed continuously.
Well, ma'am, if you want me to do what's called a Faretta hearing and make a determination whether you can represent yourself without counsel, are you prepared to do that?
Yes, I am, sir.
Okay, I mean, I can do that Faretta hearing, but I'll let Mr. Pribble go for the day and I'll hold you until we're completed with the rest of our business. I'm not gonna make all these other people wait while I go through a Faretta hearing with you, because it takes a little bit of time.
It does, okay.
And I'm
Is that-
gonna ask, Bill,
Is it
can you?
possible I can come back?
What'd you say, Judy?
Court recalls case
What'd you
before
say?
Brandon Hampton.
Okay.
So here's a form that I need you to review.
Mr. Hampton, what's
And,
wrong with you and why'd you do that?
You can step back and then I'll call you back up here at the end. We can go through the Faretta with you.
Can I come back?
Come back when?
What
All
time
right.
is it? Around 12:30?
Here's what I'm going to
Oh,
do.
no, ma'am.
Mr. Hampton, that behavior is not going
I
to be tolerated
don't
in
have
my
time at
courtroom. At this point,
12:30,
I'm revoking
but I have
the
time around
defendant is
11:30.
remanded
So,
to
I mean, like I'm saying, you can
jail.
step back.
I'll move this
We
hearing
will
up
not
to next
conclude your
week,
matter,
November 14, 2024
today. We'll let Mr.
at 9
Pribble
a.m.
not have to be present for the Faretta hearing, since it's just regarding whether she can appear pro se, and I can talk with her directly about that.
Okay.
So you can wait until the end of our call and then come back and we can handle this.
Okay, thank
Okay?
you.
All right. Is that all you had, Mr. Pribble?
Yeah, that's all, Your Honor.
Okay, well, I'm glad that you did the heavy lifting in this matter. I'd like to conduct a Faretta hearing.
Approach.
Yeah, I have one here, but I'll use this one. That's fine.
As well as.
Ms. Butler, please raise your hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes.
Okay, thank you. All right. Are you
Court
under
recalls case
the influence
before
of any
us,
alcohol or
Brandon
drugs
Hampton.
today?
No.
All right. Yeah, we set a trial already. You're set.
Mr.
trial
Hampton,
set
what's
for
wrong with
August
you? Why'd you
18th
do that
and
on your way
19th.
out?
And you've indicated you want to represent yourself. Did you have a chance to review the pro se waiver rights form I presented you in open
All
court?
right, counsel,
Looked at
here's what
it
I'm gonna do.
a little
Mr. Hampton,
bit.
that behavior is
Did you
not
sign
gonna be
off on that?
tolerated in my courtroom. At this
No, I
point,
did
I'm
not
revoking
sign off on
defendant's
it
bond.
yet.
Defendant is remanded
Okay,
to
would you
the
like to have
Washington
more
County
time to
Jail.
review it before
I'll
you
move
sign
this
it?
hearing up to next week, November
Yes,
14th,
can
2024
I get the
at
second
9 a.m.
page, please?
You may
Because I
take
have written on the back of it.
I'll give you a
Have
whole
a
new one.
spare? I'm just gonna give you a whole new one.
Approach.
Can I also address something? You just let me know when I can.
Go ahead.
When we spoke earlier about the document that was submitted, I just want to inform you that, the head clerk is aware of it. Since May 11th, they've been working with me, providing me all the accounting. What you just gotten just now, I think one of your staff did not follow the correct procedures. So,
Approach.
I was want to let you know that my estate
Sure.
has not been abandoned. I also want to let you know that I did not appoint anyone to administrate my estate. So, for that being said, I'm coming here with honor, clean hands, and no controversy. I do not want to argue about anything. I just
Court recalls
want
case
it
people
to be
versus Brandon
settled,
Hampton.
closed, and gone.
Mr. Hampton,
Okay,
what's
ma'am.
wrong with
Anything
you?
else?
Why'd you do that on your way out?
When you do present another date for me to come
All right.
in, would I be
Counsel,
able to
Here's what I'm gonna
talk
do. Mr.
about this
Hampton, that
matter?
behavior is not gonna be
How
tolerated
this
in my
all
courtroom.
led
At
up
this
to,
point,
because
I'm
I
revoking
really never
defendant's
got a
bond.
chance
Defendant
to
is
even
remanded to the
speak to no
Washington
one.
County Jail.
I've been
Yeah, ma'am,
I'll move
that's
silent.
what
this
the
hearing
jury
up to
trial's
next week,
for,
November
okay?
14th,
All the facts and
2024 at
circumstances
9
related to
a.m.
the case,
You may
state's
take it.
evidence, everything of that nature would come out during the jury trial. So I need to go through this Faretta hearing with you, ma'am.
Okay,
You've indicated you want to represent yourself at trial. You have a right to do that, just as you have a right to have counsel present and have a court-appointed counsel if you can't afford one. But before I make that decision final, I want to make sure you understand what you'll be giving up. You understand you may have a number of defenses which apply to your case, which an attorney is trained to know. Do you understand that?
I comprehend.
Okay. And do you realize that if you were convicted of the offense in this case, that you're facing a possible penalty, 2 level 6 felonies. So each one of those would carry between 6 months to 2.5 years in prison.
Approach.
So the total combined
Sure.
penalty could be 1 year to 5 years in prison. Do you understand that that's the possible penalty?
I comprehend that as well.
You realize there are factors the court can consider in increasing your sentence within that range or in decreasing your sentence within that range, and that those are called mitigating and aggravating
recalls case people
circumstances,
versus
and that a
Brandon
trained
Hampton.
attorney knows how to identify those and present those to the court.
I comprehend.
Mr. Hampton, what's
Attorneys
wrong
have
with you?
developed
Why'd you
certain
do that
skills
on your way
in
out?
investigating your case, interrogating witnesses, and finding favorable witnesses and obtaining their testimony. They can explain
All
the
right.
charges and any
Counsel,
lesser known included
Here's what I'm
or
gonna
lesser
do. Mr.
included
Hampton,
offenses
that
to
behavior
you.
is not gonna be
They can gather
tolerated in my
documents and
courtroom.
other
At this
kinds of
point, I'm
written
revoking
evidence.
defendant's
They
bond.
can prepare and
Defendant is
file
remanded to the
motions
Washington
before
County
trial,
Jail.
such
I'll
as
move
motions
this
for a
hearing
speedy
up to
trial,
next week,
motions
November
for
14th,
discovery, motions to keep
2024 at
unfavorable
9 a.m.
information from being
You may
received
take
as
it.
evidence. They know how to examine and cross-examine witnesses at trial. They can recognize objectionable and unfavorable evidence and promptly object to its use. They can present favorable sentencing information and attack unfavorable sentencing information. At a jury trial, they can present favorable opening and closing statements, prepare appropriate written jury instructions, and select a jury. They have the training, knowledge, and skill at properly preserving the record of the case for purposes of an appeal. An attorney can also evaluate the strengths or weaknesses of the case against you and give you expert advice on whether you should attempt to seek a plea agreement with the state, which may result in the dismissal of some of the charges and a recommendation for a favorable sentence in return for your plea of guilty. Do you understand all that?
I comprehend it.
Okay.
Court recalls
You must
case
understand if
before
you decide not to have an
Brandon
attorney, you will not receive any special treatment with your defense. You have to follow the same rules and procedures in your case
Mr.
as an
Hampton,
attorney
what's
would
wrong
have to
with you and
do.
why'd you do
You
that on
understand
your
that?
way out?
Yes, I comprehend that, so.
Okay, so you filed these documents with the court, and these documents make
All right.
statements about an office
Counsel,
of executor
Here's what I'm gonna do.
observations,
Mr. Hampton, that
findings
behavior is
regarding
not gonna be
Porter County
tolerated in my
Superior Court
courtroom. At this point, I'm
interaction
revoking
with Tierra
defendant's
Lene
bond.
Butler.
Defendant is remanded to the Washington
You
County
talk
Jail.
about
I'll move his hearing up to
final
next
order to
week,
settle
November
and close,
14th, 2024
different things
at
like
9
this,
a.m.
and then there's
You may
like
take
a recitation of chronology, different things of that nature. And a few minutes ago, you mentioned something about how the clerk's office is helping you like settle your accounts and different things of that nature. You understand that those aren't themes or processes that are part of the criminal court proceeding?
Well, I had did some research on my case, and I noticed that I had in a,
That's not the question I asked.
no,
I think you misunderstood the question.
it's not criminal. It's not criminal.
Oh, you're here in a criminal proceeding. Do you understand that?
Yes, I am in a criminal proceeding, but like I've been trying to explain, ever since when I had,
Well, I need you to answer the question I asked you, okay, which was whether you understand that these documents and things that you
Sure.
follow with the clerk's office, what's the receipt date on this?
it should be April 16 or 15.
April 16th it was received, so just yesterday.
Mhm.
That these aren't criminal matters that you filed with the court?
Mhm. Those aren't criminal matters, the violations that have been
Court
been
recalls
held
case
against
before us,
me.
Brandon
Yes,
Hampton.
that's a lot of
You
violations.
understand they're not, though? I mean, these aren't things of a criminal nature that would be part of this
Mr.
criminal
Hampton, what's
case.
wrong with you
What
and
you
why'd you do
saying,
that
what
on
I
your way
just
out?
found is not what criminal?
This
Explain a little bit
document,
clearer.
these
All right.
papers seem to indicate that you're
Counsel,
trying to proceed in
Here's what I'm gonna
equity
do. Mr.
or
Hampton,
under
Yeah,
that
some
that's-
behavior
sort
is
of
not
a
going to be tolerated in my courtroom. At
pseudo-legal
this point, I'm
jargon,
revoking defendant's
some
bond.
type of
Defendant is remanded to the
Is we in the
Washington
Article
County Jail.
Court 3 right
I'll
now?
move his hearing up to next
Say
week,
again?
Are we in the
November
Article
14th,
Court 3
2024
right
at
now?
9
I don't
a.m.
understand what
You
you
may
mean.
take it.
This is the
Means
Supreme
that,
Court of Porter County.
okay, so we basically still in the same court as administrator. So you're basically trying to administrate a mistake. But I was letting you know.
Okay, Ms. Butler, you understand that these administrative things that you're talking about aren't part of this court proceeding?
I know, I'm aware of that. I was talking to myself. But what I'm saying is, I have done some research, okay? And I actually wanted to address it. And I'm not getting no assistance with the public defender, okay?
What are you trying to address, ma'am?
My innocence of the matter. And also the violations, the due process, the unverified information, the lying, the evaluation.
Sure.
I've been forced to be drugged without a cell hearing. My evidence that was held from me when the what's his name? Jeffrey Clymer had ordered the prosecutor to meet me in private to see my documents. I mean, the evidence held against me, and he
Court recalls
refused
case
to
before us, Brandon
present them
Hampton.
to me. That's a brandy violation because it worked in my favor when I first got it. Then
Mr. Hampton, what's
also
wrong
on
with
the
you and
record,
why'd you
I'm
do
trying to
that
get
on
you
your
through
way
this
out?
Faretta hearing.
I know, but you asked me, and I'm trying to explain the violations. Okay.
Right, but
All right.
those aren't violations that
Counsel,
are
They
Here's what I'm
are.
part
gonna do.
of
Mr. Hampton, that
this
behavior
court
is not gonna be
proceeding.
Now,
tolerated
on
in
this
my
court
courtroom. At this
proceeding-
If you
point, I'm
have something
revoking
that you
defendant's bond. Defendant
plan
is
to
remanded
file
to the Washington County
related to
Jail.
that,
I'll move
it
his
has to be
hearing up
filed through
next
your
week, November
attorney
14th,
because you still have an attorney.
2024
I did that
at
too.
9
You know what
a.m.
he did?
You may take it.
I don't know, ma'am.
Ignored.
What you have filed through the clerk's office, you're saying are that matters in equity. We don't recognize what you're talking about in
You
these
guys are-
filings.
This is a bank. This is a bank. I understand how the.
What'd you
court-
say?
This court system operates like a bank.
Okay, it doesn't, ma'am. This
It
court system
operates.
doesn't operate like a
Yes,
bank
sir.
any way
Approach.
whatsoever.
Hold on, let me finish.
No.
Sure.
I'm not gonna let you finish that
Okay.
particular statement.
I said, I want to
Because
preface
I
this.
just
Don't
need-
want to argue
I need you
anything.
to,
I just want you to
redirect-
understand me mentally.
I did the mental thing just fine.
Okay.
I'm not worried about any mental thing.
Okay.
What I'm worried
okay.
about is the conception you may have that this is some sort of court of equity or some
Court
sort of a
recalls case,
business
people versus
transaction,
Brandon
some
Hampton.
sort of a bank, something of that nature, because it is none of those things. You realize that? This is a
Mr.
criminal
Hampton, what's
court.
wrong with you? and
Yes,
why'd
it
you
is. This
do that
is,
on
the
your way
setting
out?
is.
We're not an Article 3 court. That's a federal concept.
Yes.
You understand that?
Yes, I am.
Okay, we're an Article 7
Mhm.
court,
All right.
if you must know,
Counsel,
in the state of
here's what
Indiana.
I'm gonna do. Mr.
Separate
Hampton, that
judicial
behavior
branch.
is not gonna be
Yes.
tolerated in my
Not
courtroom.
any
At
of the
this
things
point,
that
I'm
you've said
revoking
here.
defendant's bond.
Yes.
So
Defendant
what
is
I need you
remanded
to
the Washington
tell me
County Jail.
is
I'll
Okay.
move
whether
this hearing up to
you
next week,
are
November 14th,
understanding that you have to
2024 at
follow,
9
if
a.m.
you're going to
You may
represent
take it.
yourself,
Mhm.
you have to follow all the rules and regulations that are promulgated by the courts of Indiana. You have to follow the criminal rules. You have to follow the trial rules.
Yes.
Will you do that?
Yes, yes,
You
yes.
will do that.
Yes.
So you understand that what you filed yesterday can be stricken under the record. Under the trial rules, under Indiana Trial Rule 12F, because it's impertinent to anything that is going on in this proceeding. You realize that?
I understand that in a sense, but like I keep explaining to you, it was not supposed to be filed in the court. That's the difference.
You filed it at the clerk's office.
Yes.
Well, let's carry that out for a
Yes,
minute.
it's a difference.
What's the name of the clerk's office?
The clerk's office
Approach.
is the clerk of clerks.
Clerk
Clerk of clerks. Yes.
of courts, right? So there are
Yes.
clerks. So if you
Yes.
file something and you have a case pending, they send that to your case. Unless you try to open a case of your own,
No,
you're trying to open litigation of your own.
no, what I am,
This has to be presented in your court case here that you have pending before
Court recalls
us.
case,
Okay.
people
So
versus
you will
Brandon
not
Hampton.
strike it?
Rules.
you won't strike it down or you will strike
Oh,
it?
it has to be stricken. It is impertinent to
Mr.
anything
Hampton,
we're
what's
doing
wrong
here.
with you and why'd you do that
understand?
on your way out?
No, I don't understand.
Okay.
How you
You
just
have
strike-
filed documents making commercial demands, demanding accountings,
Yes.
challenging the capitalization.
Here's what I'm gonna do.
No, you
Mr.
didn't do
Hampton, that
but,
behavior is not
challenging
gonna be
different
tolerated
things
in my
about
courtroom. At this point, I'm
um,
revoking defendant's
who
bond.
you
Defendant
are
is remanded to the Washington
who
County
you
Jail.
would in equity
I'll move
Yes.
this hearing up to next
And for
week,
me-
these kinds of
November
things.
14th,
Ma'am,
2024
you understand
at
those have
9
no
a.m.
basis in
You
Indiana
may
criminal
take it.
law.
Okay,
You realize
But-
that?
but let me explain, can I make a statement to you then? You said there's no basis in criminal
Go
law.
ahead. What's your statement?
Well, I also want to say something. And also I am a minister and I want to read this on the record, okay? And it states that should a man prove himself to be living and not dead, nor lost of sea, his estate must be returned to him with mean profit. I am the living man that have accepted appointment of this office of executor. As such, this office give notice of its accusations and findings. And now I have issued orders, okay? And in the scripture, the living and the spiritual man judgeth over all things, yet he shall be judged by no man. And that's 1 Corinthians chapter 2, verse 15. Like I said, I came here with clean hands. And I'm now the executor. My estate has no longer been abandoned. And I don't allow no more trespassing
Court
and
recalls case,
interloping
people versus
upon and
Brandon
administrating it. I discovered a lot of things along the
Mr.
way.
Hampton,
put
what's
me
wrong
in
with
this
you and why'd you
position.
do that on your way out?
Okay, ma'am. Clean hands is an equitable doctrine. You understand that?
Counsel, here's what I'm going to do.
If this is
Mr.
not a
Hampton,
court of
that
equity,
behavior is
if
not
you
gonna
were
be
in court of
tolerated
equity,
in my
you
courtroom.
wouldn't
At
even
this
be
point,
given
I'm
or
revoking
afforded the right
defendant's
to a
bond.
jury.
Defendant is remanded to the Washington County Jail.
I
I'll move
think
this
it's
hearing
appropriate
up
for
to
me
next
at this
week,
time
November
now to
14th,
terminate the Faretta
2024
inquiry,
at 9 a.m.
deny your
You may take
request
it.
to proceed pro se. I'll specifically find that the request is not a genuine attempt to present a legal defense, but a calculated strategy to obstruct and subvert the court's proceedings. The defendant's utilizing rhetoric of what would typically be called a sovereign citizen movement,
No.
including raising nonsensical
No.
challenges
No.
and attempting to apply commercial law to criminal prosecution
No.
or equitable law.
No, that's not
Ma'am, you
true.
keep saying no, but you're talking over me and I don't appreciate it
Approach.
because I'm trying to rule. The right of self-representation is not a license to abuse the dignity of the courtroom or ignore relevant rules of procedure and substantive law. Based on the defendant's filings and her statements in open court, the court finds she's unwilling to comply with rules of procedure and intends to use self-representation solely for deliberate disruption of the proceedings. The request to proceed pro se is denied and
Court
appointed
recalls
counsel will
case
remain
before
on the
us.
case.
Brandon
We're